We heard this morning about the wealth planning needs of Russian clients. They are looking for stable solutions which offer them asset protection, flexibility, succession planning, privacy.
The next speaker is Jan Dash, Managing Partner at Liburn & Dash.
Good afternoon, my name is Jan Dash. I'm an attorney in a beautiful Caribbean island called Nevis, which is part of St. Kitts and Nevis, and I'm here today to talk to you about setting up a private trust company and the ownership and management options for a private trust company. Now, we're all familiar with your typical commercial trustee situation. At the bottom, you've got the assets. It's owned by an investment holding company. It's owned by a commercial trustee through a trust. The client and their family are beneficiaries of that trust, and the client signs a document with the trustee that says that I am settling this trust. Another way to establish a trust is to declare a trust. The client just basically gives the money to the trustee, and the trustee does the same thing. Sometimes the client is very concerned about the situation because it is a hard sell. You've got a client who, let's say he owns a supermarket or owns a chain of supermarkets, and he's worked hard all his life, or she's worked hard of her life to develop this supermarket, and all of a sudden she's being asked to give all her assets to a trustee that's a bank or a commercial trustee in a jurisdiction that you don't know. So sometimes you use a protector. In recent years, there's been concerns because of the Rahman case, concerns that the clients and their advisors have about the whole situation. And in a way to remedy this, offshore service providers have come up with a way to please both sides. One of the ways is reserve powers in a trust, basically allowing the client to have some powers over the trust. Another way is a letter of wishes, which is not really worth the paper it's printed on because, again, it's pretty much described itself. It's a letter of wishes. It doesn't have to be followed by the trustee. The best possible way is probably a protector. But a protector can do whatever the protector wants, which may not be what the client wants. This has led to an increased interest in family offices or private trust companies. Now, a private trust company or family office can be described as a company which is incorporated to act as a trustee of a specific group of related trusts and the director of a related group of underlying companies. As with many things, there are benefits and burdens. The advantages of a private trust company, it allows the client to remain involved with their money. Now, we all know it's not their money, it's the trustees' money for their benefit, but that's a hard concept for some people to understand. So it allows them to remain involved with their money. It also avoids the possibility of a sham. If it can be shown to be seen that the client is so involved in the day-to-day administration of the trust, it can be said that the assets never left the control of the client. The trust would be declared a sham, and there would be negative tax and creditor issues. The disadvantages, the lack of understanding of the whole trust concept. You've got a client who owns a supermarket, he understands tomatoes, he understands carrots, he understands things of that nature. His attorney doesn't understand anything about trusts. So when you're asked to manage your own trust company, it's a bit of a difficult hump for them to overcome. That can be overcome by retaining the services of an attorney in the jurisdiction to advise on a periodic basis. Another possible burden, if you've got the family managing the family's money through a trust, there's a greater possibility of some kind of breach of fiduciary duties. If it happens when a commercial trustee does it, they have director's insurance, they're what's known as a deep pocket, and they're going to be forced to pay. If it's the family, there could be a potential problem. Another potential problem is family politics. If you've got two sons who have always been at each other's throat, dad is now dead, and these two sons are being asked to run the trust company, there's going to be a problem. So that's something that needs to be concerned about beforehand. Now, there are three options when it comes to managing a private trust company. The first option is not really an option. The second option is probably the most popular option, and the third option is the option that I would suggest. The first option is having it owned by the client. The second option is having it owned by the Purpose Trust, which is the most popular option. And the option we're going to discuss today is having it owned and managed by a foundation. Now, this is a chart of a PTC owned by the client. Again, the assets are at the bottom. The investment holding company is just above that. The trust is above the investment holding company, and the private trust company owns the assets through the trust. The client's family of beneficiaries of the trust, and the client is the shareholder of the private trust company and the director of the private trust company. There's going to be problems. Well, the benefit is that the client has the control over their structure. The disadvantage is that they have direct control over their structure. There's going to be tax and creditor issues because there's a direct link between the ownership and management of the entity. There's also the potential for contingency issues with the board, and which needs to be carefully considered before it's done. The most popular option, I think, is the most confusing option. Again, you've got the first four levels we're pretty much familiar with. After we get above the fourth level, the second rectangle, we see the Purpose Trust. The Purpose Trust has a Purpose Trust trustee as a director and shareholder, and the PTC has its own director, and the Purpose Trust has a protector. Now, the reason that there's all this confusion, shall we say, if you use a Purpose Trust, it needs to have a protector. If it's a beneficiaries trust, shall we say, the beneficiaries are the ones who would ultimately enforce the duties of the trustee. If it's a Purpose Trust, there is no person to enforce the duties of the trustee, so there's got to be a person to basically step up to the plate and say, listen, Mr. Trustee, you're not doing your job. So hence there needs to be a protector. Now, of course, there are advantages and there are disadvantages. The advantage is that the client has indirect control over the assets. There's no direct link between the client and the ownership of the trustee. But as the last diagram has shown, it's a little bit more complicated than it needs to be. Again, we've got the Purpose Trust with the protector. The Purpose Trust has a Purpose Trust trustee, which has a director shareholder, and the private trust company has its own director. A foundation is probably the best way to set it up, and let me just go over foundations for a brief second. A foundation can be described as a self-owned entity which has been endowed by a subscriber to be used for purposes or persons. A management board is appointed to make policy and administrative decisions on a day-to-day basis. Now, there are differences between trusts and foundations. A trust can only act through a trustee. It's not an entity in and of itself. It's basically a private agreement between two parties. A foundation is a separate legal entity and can sue and be sued, and it can make decisions on its own. In a trust, the settlor is required to relinquish control. In a foundation, the client, the subscriber, may be on the board of the foundation. The letters RAP means rule against perpetuities, and it's been eliminated in a bunch of jurisdictions. In a trust, the settlor must worry about a rule against perpetuities. The rule against perpetuities, for those of you who don't know, it's basically an old English common law rule that says that assets cannot be tied up forever, essentially. A foundation may exist forever. Now, foundation legislation exists in many jurisdictions. It started off in continental Europe in the Middle Ages. The conventional wisdom at the time felt that when the knights went away to fight their wars, the assets needed to be managed by someone. The assets were given to the church for charitable reasons, but the church didn't feel that they should be in the business of asset management, and the asset should be able to manage itself. So hence the concept of a foundation. Foundations were strictly used for charitable purposes for a couple of centuries, up until 1926. In 1926, Liechtenstein enacted a commercial foundation law, followed in 1995 by Panama, followed in 2004 by Nevis, and we were the fourth in the world to establish a commercial foundations law, and the second common law jurisdiction. Nevis is part of the Federation of St. Kitts Nevis. We're a two-island state. It's in the Caribbean. We received our independence from Britain in 1983, and I'm proud to say that my business partner, Herman Liebert, was a member of the negotiating board that allowed us to achieve our independence. Nevis is allowed to enact its own laws, and we have done so in the offshore financial services sector. Now, this is basically a map of Nevis. As you can see in the upper right-hand corner, that's a map of the world. Then we focus in on a map of the Caribbean, and Nevis is halfway between Miami and Caracas. And on the left-hand side, you can see Nevis is the one that's shaped, is a circular-shaped island, and St. Kitts is the one that's shaped like a chicken leg. We've got several pieces of offshore legislation. The Nevis Business Corporations Ordinance, a trust ordinance, a limited liability company ordinance. A limited liability company ordinance is pretty much based on the LLC laws or limited liability company laws of Delaware and several American states. We've got a banking ordinance, we've got an insurance ordinance, and we've got a mutual funds ordinance. Having worked on amendments for several of these ordinances, I can tell you that the Business Corporations Ordinance, the Trust Ordinance, the LLC Ordinance, the Insurance Ordinance will all be amended hopefully before the end of this year. The Banking Ordinance is going to be repealed and replaced by a new one, and the Mutual Funds Ordinance is going to stay the same. Now, we also have a Foundations Ordinance, and it was written by a gentleman named Stephen David Jones, who's an attorney here in London at a firm called Gyre House. And we call our Foundations Ordinance the Multi-Form Foundations Ordinance. It's called the Multi-Form Foundations Ordinance because it can take the form of a standard foundation, or it can take the form of a company, corporation, trust, or partnership for management purposes. It can be done for a beneficiary, it can be done for a purpose. In a trust, the beneficiary has the right to see the trust deed. Under our foundations law, the beneficiary's right for information may be limited or eliminated. All foundations are tax exempt, but they can be tax resident and pay taxes at a maximum rate of 1%. All legal action against foundations must be brought in the High Court. We don't recognize foreign judgments against foundations. We don't recognize judgments against trusts either. And all hearings, except for criminal matters, are in camera or held in judges' chambers. There's also a limited statute of limitations for fraudulent conveyance, basically between 6 months to a year. Now, this is what a structure of a foundation would look like. A PTC owned by a foundation would look like. Again, we've got the assets at the bottom, the investment holding company, the trust with the beneficiaries, the PTC, and then we've got the foundation at the top in the red sexagram. We've got the management board. Unfortunately, there's a requirement to have a secretary that's separate from the management board, and the subscriber is the client. A very, very simple way to set up a PTC. If the client wants to get a little bit more complicated, they can have a supervisory board, but that's strictly not necessary. The use of a PTC is the best method for clients, for high net worth families to play an active role in the management and administration of their trust structure. A PTC, which is owned by a multi-form foundation, allows families to have the opportunity to become involved in the legal and constructive ownership of their trust structures while engaging in the management of the entity and enjoying the benefits of creditor protection and privacy. A PTC incorporated as a Nevis Business Corporation, which is owned by a Nevis Multi-Form Foundation, provides many benefits to all interested parties. There is no licensing requirement for PTCs, and the entity may charge fees to the client if it wishes to do so. There is no limit to the number of trusts that a Nevis PTC may act as trustee for, and there's no requirement that there be any relationships between the trusts which are administered. A PTC enjoys a high level of confidentiality when it's owned and managed by a foundation. A foundation is a self-owned structure and a legal person and can bring and defend actions. A foundation established under the laws of Nevis can assume the form of the standard foundations or more recognized structures for administrative purposes. The laws of Nevis do not recognize foreign judgments against an international trust or a multiform foundation, and any person with an interest therein. All actions must be brought in the High Court of the Federation. And there is a 6 month to 1 year statute of limitations for actions for fraudulent conveyance. We know that in planning your structures, you have many options, and you have many jurisdictions that you may choose. And we just hope that you would give Nevis the opportunity and set up a PTC in the beautiful Caribbean island of Nevis. Thank you again for your patience and attention. Besiba to my Russian friends. And my name is Jan Dash, and I look forward to hearing from you. Thank you very much.